Hello friends, welcome to Insightsias initiative. In yesterday we started the prelims high yielding series and we started with the quick revision of the fundamental rights topic which covered in last 1 year. That was the part 1 and today we are going to finish the part 2. So with this we covered the 12 most important topics related to fundamental rights which spanned around last 1 year. Okay, in today's video we are going to discuss about following 6 topics. Gyanvapi Mosque controversy, it is mainly related to Article 25, right to freedom of religion. Same-sex marriage, it can be Article 21, right to life. And of course Article 19 as well. Then abortion rights, right to life. Article 21, women reservation bill, it is related to Article 15 and Article 16. And of course it is also related to Article 334. Because this women reservation this time it is related to the Parliament and Assembly as well. OBC Sub-Categorisation Commission, it is related to sub-categorization of OBC. It is also related to Article 15.4 and Article 16.4, 4A, 4B and certain other articles. And finally UAPA Act. You know that news click agency, that head of the news click agency, he was arrested under UAPA. It was a talking point. In today's news also it was there. So we discuss about the preventive detention, various provisions mainly related to Article 22. So this is where we are going to discuss about all the 6 topics. Once today's class is done, okay, so you have to tell me, so which subject or in polity, which topic you require for rapid revision based on your request. I'll put that as a priority order. And most probably, as we are done with the fundamental rights for last 1 year, we'll try to cover other topics in polity like parliament related to updates and some other topics. And of course, at the end of the day, it's your choice. You have to put your inputs. So based on that, I'll go ahead. So regarding the Gyanvapi Mosque controversy, it is related to Article 25 and it is all about the converting of a religious place. Actually, it should not be done according to the Place of Worship Act 1991. Now, let us read out the context. The Archaeological Survey of India, it submitted a report, and the report is saying that there is existence of Hindu temple before the mosque constructed in that place. This is the Archaeological Survey of India report. Actually, the case chronology, in 1991, group of priests in Varanasi, they petitioned in the court and they sought the permission to worship at the Gyanvapi premises. And they sought the restoration of the Gyanvapi land to the Kashi Vishwanath temple. And the claim is that mosque was constructed under the orders of the Aurangzeb, who was tore down a part of the temple in the 16th century. This was the petition. And here the mosque committee saying that they have the right to worship, and according to the Places of Worship Act 1991, a particular religious place character should not be changed. It is barred unless until it met with certain criteria. We will discuss about that criteria. Allahabad High Court dismissed their play initially. Then Supreme Court 2022, it directed the protection to the specific area where the Hindu community is claiming in this Gyanvapi Mosque, and the rest of the area is allowed to the Muslims to pray in the mosque. That was the Supreme Court last stand. Regarding the Place of Worship Act 1991, according to this, a place of worship and its nature must be remain as same like 15th August 1947. That means any religious place which is declared related to particular religion on 15th August 1947, it deemed to be continued like that. Its nature cannot be changed. Of course, there are certain exceptions. Okay, exceptions we will read out. And it is saying that no person shall convert any place of worship of any religious denomination into another denomination, of course. And here it is mainly brought mainly to settle down all the disputes related to places of worships. Of course, this act outlined certain exemptions. This act is not applicable to ancient and historical monuments, archaeological sites, which covered by the Ancient Monuments and Archaeological Sites and Remains Act 1958. This act also does not applicable to Ram Janmabhoomi Babri Masjid in Ayodhya, because by the time of this enactment of this act, by the time this issue, it was in court. That is the reason this dispute kept out of the purview of this act. And the Archaeological Survey of India, this was founded in 1861 by Alexander Cunningham. Ministry of Culture it comes under, and their main duty is maintenance of ancient monuments and archaeological sites. Tell me students, how many places in India got UNESCO World Heritage Sites? UNESCO World Heritage Site status. Next, According to the provisions of the Ancient Monuments and Archaeological Sites and Remains Act 1958, it regulates Antiquities and Art Treasures Act 1972 also comes under this particular Archaeological Survey of India. So this is about the topic number 1. Next, topic number 2, same-sex marriage. 5-judge bench of Supreme Court headed by the CJI, it denied in giving legality to same-sex marriage. We will find out what are the reasons might be. Okay, the Supreme Court observed that it is the duty of the Parliament or state legislature, they should make relevant acts to make this same-sex marriage as a like legalized one. And this one, the same-sex marriage, it cannot be legalized by using the existing provisions under the Special Marriage Act. And the queer couple, they can have a right to enter into union. That means they can live together. But the legalizing the marriage, it is up to the legislative bodies. That is the observation of the Supreme Court. The state duty, it has to give protection if necessary to the couple who require the special needs. Here the queer and unmarried people, they can jointly adopt children. Very, very important provision, because the same-sex marriage, both the people, if they belong to the same sex or if they belong to the queer couple, queer means they are not sure about their gender identity. They cannot adopt children unless until one person should be the normal one. Okay, an unmarried person should be there. The two queer couple, the two people who belongs to the queer category, they cannot adopt according to the Supreme Court judgment. And center should adopt or center should proceed forming committee regarding legalizing the same-sex marriage. Of course, Government of India is also not positive about this same-sex marriage. We have seen later. And the judgment takeaway: no legal protection to the same-sex marriage, and no constitutional right to civil unions. And center's high-powered committee will examine the concerns regarding the same-sex couple, and no right for queer couple to jointly adopt. Only one can be queer, but another must be unmarried person. Next, Section 377 related to this particular topic. Section 377 of IPC, previously it criminalized same-sex cohabitation, but in 2018 Supreme Court decriminalized the Section 377 of the IPC. In this particular case, Supreme Court commented that consensual adult sex is not a crime, and it decriminalized the Section 377. And next, the Special Marriage Act 1954. So here Supreme Court mentioned the Special Marriage Act 1954. So we try to revise the Special Marriage Act 1954. It is an act made by the Indian Parliament with the provisions regarding the civil marriage for couple of India and all the Indian nationals in foreign countries, irrespective of the religion and faith, who want to go for interfaith or who don't want to go according to any religious practices in their marriage, they can go according to the Special Marriage Act 1954. Next topic, abortion rights. So Supreme Court in India granted permission for a 27 weeks old pregnant woman to undergo medical abortion. You know that in India, abortion is regulated through Medical Termination of Pregnancy Act 1971. According to this particular act, so who can get abortion, where they can get abortion, and in what stage they can get abortion, all these things will be regulated by the Medical Termination of Pregnancy Act 1971. Of course, recently we put certain amendments to the Medical Termination of Pregnancy Act. We will discuss about what are those amendments. Okay, so here the case is about a woman who is a victim of a rape. She cannot be forced to have a child. It is affecting on her mental health as well as it is against the constitutional philosophy. Such pregnancy affects physical and mental health of the woman. Court set aside an order previously given by the Gujarat High Court which denied the abortion to that woman. Next, they noted the cultural importance of the marriage, and these are the main differences between the Medical Termination of Pregnancy Act 1971 and 2021. Previously in 1971, so up to 12 weeks, 1 RMP, and up to 20 weeks, 2 RMPs. Their advice is required. Here this change, now up to 20, 1 RMP approval is enough. Up to 24 weeks, 2 RMP, so approval is enough, and beyond 24 weeks, abortion can be allowed only in exceptional condition, that too on the approval of the medical advisory boards. So this Medical Termination of Pregnancy Act, it regulates who can terminate their pregnancy, until when they can terminate the pregnancy, and where they can terminate the pregnancy. When pregnancy exceeds 20 weeks, but not 24 weeks. Termination can be possible with the opinion of the two registered medical practitioners. And the eligible about 24 weeks. Beyond 24 weeks, women can avail the abortion only under certain conditions. Those conditions are unmarried women who subjected to the rape or the sexual violence, and if it is a minor, then obviously when the case also should be filed according to the POCSO Act. If the pregnancy is a result of incest or rape, major deformation in the fetus, if the pregnancy is a result of the failed contraception, and if the continuation of the pregnancy is a grave injury to mental or physical health of the mother, in case of the miscarriage, that is, unfortunately, if the baby is dead inside, in this condition, medical termination of the pregnancy can be allowed even beyond 24 weeks as well. And one more relatable legislation is, in 1994, the PCPNDT, Preconception and Prenatal Diagnostic Act, it was implemented, and according to this act, it is illegal regarding the gender determination. If anyone subjected to this particular gender determination and that medical practitioner, and the action will be taken on that particular medical practitioner. The Women Reservation Bill. According to the 106 Constitution Amendment Act, women reservation is provided in the Lok Sabha as well as the assemblies. And this bill is providing around 33% women reservation to in these lawmaking bodies. And you all know that in Rajya Sabha there are no reservations. In legislative councils also there are no reservations. And here the reservations will be subjected to review after every 15 years. This amendment added Article 334 Clause 2. Okay, and according to this provision, the 1/3 reservation will be provided in the categorization of SC/ST as well. And tell me students, this particular reservation is horizontal reservation or vertical reservation? Which type of reservation it is? Women Reservation Bill. Already we are providing the women reservation in local governments with the help of the Article 243 ZD. 1/3 reservation we are providing. This bill initially it started its journey in 1996. It lapsed at various times because of the dissolution of the Lok Sabha. For the first time, this bill referred in the H.D. Devegowda government. Then the bill was referred to Joint Parliamentary Committee chaired by Geeta Mukherjee. Tell me guys, Joint Parliamentary Committees are the standing committees or the ad hoc committees? They are standing committees or ad hoc committees. Which one is the right one? The status of women reservation in India. Gujarat is now providing around 8% of the it is having only the 8% of the women legislators out of the 182 member assembly. Himachal Pradesh, where women voters are around 50%, but women representatives barely only one women representative out of the 67. National average also only 8% of the women representatives are there. That means very low in numbers. That is the reason it is a need of the hour to implement the women reservation in the legislative bodies. India is also ranking very poorly. That is 144 out of the 193 countries regarding the representation of women in parliament. It is not faring good in comparison to our neighboring countries as well. Next, topic number 5. This is regarding the OBC Sub-Categorisation Commission. You all know that at the moment, reservation is providing in the ratio of SC 15%, ST 7.5%, and OBC 27%. OBC means it including all the OBCs across the nation. But the point here, what is happening, only few communities in the OBC, they are availing majority of the benefits. Almost all, around 6 to 7 castes, they are availing 90% of the OBC benefits. So to correct this, the OBC subcategorization is proposed. To work out the OBC subcategorization, Justice Rohini Commission was appointed. And this appointment done by the President. This is according to the constitutional provision. We will see that which constitutional provision is allowing the appointment of this kind of commissions. The Justice Rohini Commission submitted the report to President. And previous BC commissions appointed. These commissions, Kaka Kalelkar commissions in 1953 and Mandal Commission 1980. They studied the social as well as the educational backward of the OBCs. According to the Mandal Commission report, now the 27% reservation is giving to the OBC communities. And of course, the Mandal Commission report, this decision was challenged in the Indira Sahni judgment, and Supreme Court validated, upheld the constitutional validity of the OBC reservations. According to Article 340, President will appoint various BC commissions to study the social and educational backwardness of the BCs. OBC reservation at the moment, OBCs are getting reservations under Article 15 Clause 4. This is reservations in education. This is a result of the Champakam Dorai Rajan case. Then Article 15.5, it is providing specially reservations in education to backward classes as well as the SC/ST. Article 16.4, it is providing reservation to backward classes. 102 constitutional amendment, it upgraded the OBC Commission, which was previously statutory body, to the constitutional body. That is under Article 338(b). According to Article 15 Clause 5, which is providing the reservation to backward classes SC/ST, especially in education, it was added through 93rd Constitutional Amendment Act 2005. And Article 16(4)(b), it is providing that the unfilled vacancies which are reserved to OBCs, they will carry forward to the next notification and they should not be filled with other castes. Article 338(b) we already discussed. Justice Rohini Commission, appointed according to the provisions of Article 340 and appointed by the President. A report also submitted to President. President will lay the report before both the houses in the Parliament. Okay, if you know, tell me. Generally, President submits any reports before the Parliament during what time? Next, topic number 6, UAPA. Delhi police, they sealed the office and they registered a case against the news click agency MD under UAPA Act. Because this news agency, they are supporting the pro-China propaganda by receiving money from the China. That is the allegation. Today, Supreme Court granted bail because the grounds of arrest are not reasonable. That is what Supreme Court observed. And of course, they are not substantiating the cause. And UAPA is one of the Preventive Detention Act. Constitution is providing preventive detention under Article 22 Clause 4. And you know that according to Article 22 Clause 4, preventive detention cannot be more than 3 months. It cannot be for more than 3 months. And that if it is required for more than 3 months, a judicial advisory board will give that extension. Members in the judicial advisory board, generally they have equivalent qualification to High Court judges. From Article 22(4) to 5, 6, 7, all these articles related to preventive detention. So both Parliament as well as the state legislature can make laws on the preventive detention. But on certain areas, only Parliament can make laws on the preventive detention. If you know on which areas only Parliament can make laws on the preventive detention, you can comment. Otherwise, you can refer to Article 22. Next, UAPA represents an alternative criminal law framework. It was enacted in 1967. It is giving more powers to law enforcing agencies compared to the existing IPC. And according to the UAPA, its main aim is more effective prevention of certain unlawful activities to deal with terrorist activities. UAPA Amendment Act 2019, this was a very significant move. According to this amendment, not previously only organizations used to be identified as terrorists, they used to arrest under UAPA. But after the amendment, even government can designate individuals as well as individuals also as like terrorist organizations, and they can be subjected to UAPA provisions. Central government can designate any organization as a terrorist outfit if it commits or participates in act of terrorism or prepares for terrorism or promote the terrorism or otherwise involved in terrorism directly or indirectly. So this is about the topic number 6. Yesterday's video question. Consider the following statement regarding the right to freedom of movement. So the answer is A. Article 19 of the Indian Constitution providing the right to freedom of movement inside as well as the outside of the country. So no, only inside. It is available to the citizen of India, foreigners and legal persons like companies. Article 19 is not available. So incorrect statement. Consider the following statement regarding the right to freedom of movement provides, okay, it is incorrect statement. It is available to citizen of India. No, Article 19 it is not available to citizen of India. So which statement is correct means neither one nor two. Because Article 19 gives freedom of movement only within inside. Outside it is covered under Article 21. And Article 19 is available only to India, not to foreigners. Next, today's video question. Today's video question is, consider the following and choose the correct code. The President convenes the sessions of each house of the Parliament. He can prorogue both houses or either house. He can dissolve the Rajya Sabha. He can dissolve the Lok Sabha. Which one is the correct statement? As we reach to the end of this video, in this video we mainly discussed about high-yielding topics related to fundamental rights, which covered over the span of last 1 year. And the next videos, it is going to be the rapid revision similar to like this. If you have any queries regarding this, feel free to include your comments in the comment section. And if you have any suggestions also, include in the comment section. Thanks for watching this video. Have a great day. Jai Hind.